This is a World Arbitration Update. My name is Jose Antonio Rivas. I'm one of the co-founders of World Arbitration Update, which was co-founded 4 years ago. This is our 4th edition. And we are very lucky and honored to be here in Beijing with the incredible council arbitrators and in general the arbitration community of China. And I, as a matter of teaching, I also teach at Georgetown University. I'm an arbitrator and do investor arbitration. And because of those interests, it was a lot of fun actually to put together this panel. This panel is I believe one of that's going to be one of the milestones of World Arbitration Update. We have never done this topic before, neither in Washington Arbitration Week, which we also co-founded 5 years ago, nor in World Arbitration Update. And I say this without any shyness. I really think that this panel has the best of the best that not only in China but in terms of world knowledge. So luckily, the proceedings will be recorded, and people will be able to see it not only here but beyond. And with that, I don't want to steal our moderator's thunder because he will be presenting each one of the panelists. But let me share with you that we're also very lucky to have Professor Mark Feldman. Professor Feldman is a professor of law at Peking University School of Transactional Law, and he joined the law school as an assistant professor in 2011. He has taught more than 1,000 and served as this advisor for more than 100 students in the university. In 2019, he served as JD faculty representative of the law school 10th anniversary alumni weekend, and since 2016 he has served on the academic committee of the university in Shenzhen Graduate School. And I could go on and on, referring to his accolades in the OECD, in UNCTAD, also his presence in ATA and ASOL conferences, and so on and so forth. But I think that we're really lucky because this panel has been working inside amongst themselves to bring today's panel to you. So Professor Feldman, welcome and thank you for being here with us.
Thank you. Thank you, Jose, and to World Arbitration Update and to the Beijing Arbitration Commission for the opportunity. And Jose, I have to say, in terms of this panel, this is a busy time for me personally. It was not easy for me to make it to Beijing. When I saw who was on this panel, I booked the flight. I made it to Beijing. So thank you for really putting together an incredible panel. And I can just briefly introduce the topic and briefly introduce our panelists for today. For the topic, we will be discussing state-owned companies as investors and claimants in investment arbitration, the protection of outbound SOE investment under investment treaties, and the ICSID convention. There are significant amounts of foreign investment by SOEs, and a key question becomes to what extent should that outbound investment by SOEs be protected under investment treaties and be protected under the ICSID convention. And I think there are a few key questions we'll be addressing today. One being, should an SOE's relationship with its home state matter for purposes of determining jurisdiction under an investment treaty or jurisdiction under the ICSID convention? And if so, why should an SOE's relationship with its home state matter? And continuing the point, if so, how should an SOE's relationship with its home state matter for purposes of determining jurisdiction? So that will be the topic today. Our presenter today is Dr. Wang Liu, based at the China International Business and Economic Law Center in Sydney at the University of New South Wales. Dr. Wang recently served as scholar in residence at ICSID, only the 3rd scholar to hold that position at ICSID. Dr. Wang previously worked with ICSID as a co-guest editor for an ICSID Review special issue on SOE investment. Dr. Wang holds 2 PhDs, one from the University of Liverpool in the UK and the other from Xi'anjiaotong University in China. Ian Laird, partner and chair of the International Dispute Resolution Group at Crowell and Morin, based in Washington, DC. Ian has more than 25 years of experience representing clients in investment treaty arbitration, with a particular focus on the energy and natural resources sector. Ian holds a BA from McGill, an LLB from the University of Windsor, and an LLM from the University of Cambridge. Hugh Ken Hong, head of international arbitration, construction, and projects at Raja & Tan in Singapore, currently based in Shanghai. Hugh has more than 30 years of experience advising Chinese and international clients on major infrastructure projects and construction disputes in many parts of the world. Since 2018, Hugh has been recognized as an eminent practitioner in the field of construction by Chambers Greater China Region. Hugh holds an LLB from the National University of Singapore. Joining us virtually, Vivian Lee, Director of Secretariat in Singapore. Ms. Lee has nearly 10 years of experience in the consulting industry, specializing in construction disputes, holding an LLM in comparative and international dispute resolution from Queen Mary University of London, and a bachelor's in material science and engineering from the National University of Singapore. Cao Li Juan, Deputy Director at CTAC of the Foreign Related Department in Beijing, Equity Partner at Zhonglun in Beijing. Cao Li Juan has represented clients in over 200 arbitration cases, including investment treaty arbitration. Quite notably, Cao Li Juan was a key member of the successful defense of China in an important ICSID case. Cao Li Juan holds an LLB from UIBE Law School here in Beijing and an LLM from UC Berkeley. Dr. Wang Shuihua, who will be arriving soon, is chief partner in Beijing at Huang Zhong & Partners, holds a PhD in law from UIBE in Beijing, previously served as associate dean of UIBE Law School in Beijing, also has served as director of the Committee of International and WTO Legal Affairs of the All China Lawyers Association. So with those introductions, we will begin with our presenter, Dr. Wang.
Thank you, Mark, for your very kind introduction, and hello, everyone. It's an honor and privilege to participate in the World Arbitration 2024 China Insight in Beijing, and I appreciate the opportunity to present on state-owned enterprises as investors and claimants in investment arbitration before a panel of distinguished experts in international arbitration. So state-owned enterprises is one of the most significant and complex challenges in international investment law and arbitration. And I will discuss this issue in 3 parts: the context, the problem, and the challenges and prospects. So the context of the SOE issues. Despite of decades of state reforms and privatization, SOEs remains an important economic force in the world economy. According to the UNCTAD's estimates, there are approximately 1,500 SOEs with over 86,000 foreign affiliates operating worldwide, controlling trillions of dollars in foreign assets. Geographically, over half of SOEs are from developing economies, such as China, Malaysia, Vietnam, South Africa, and Russia, while 1/3 SOEs are headquartered in the European Union. In response to the COVID-19, governments have implemented various of measures to support businesses, so that potentially increased the number of SOEs, especially in Europe. And in terms of the sector focus, SOEs are particularly active in strategic sectors, such as energy and natural resources, infrastructure, transportation, and telecommunications. Although foreign investment by state-owned enterprises is not a new phenomenon, their significant global expansions, especially from countries like China, has raised widespread concerns in host states, notably regarding the national security and anti-competition. These issues primarily stem from the state ownership and the exercise of governmental functions that characterize the identity of state-owned enterprises. However, the emergence of the so-called SOE issues in recent years also highlights a clash between different models of economic developments, as well as the impacts of geopolitical and geoeconomic considerations. So what's the problem? Given the prominence of SOEs in foreign investments, along with the associated regulatory it's no surprise that SOEs have relied on investment arbitration to resolve their disputes with the host states. International investment law has established a powerful investor-state dispute settlement, the ISDS mechanism, providing foreign investors against with procedure and substantive rights that can be directly enforced against host states and their entities under international play. To clarify, investment arbitration is not exclusively based on investment treaties, but can also be based on the investment contracts or domestic law of the host states. In fact, SO investors from both developing and developed countries have turned to arbitration against the host states based on investment contract or the applicable investment treaty. The primary and fundamental problem in investment arbitration when involving SOE as claimant is one, whether SOEs are qualified investors, and two, whether SOEs have standing before the investor-state arbitration. So the first question relates to the definition of investors under the investment treaties. Generally, investors is defined broadly, including both natural persons and legal persons. And the majority of investment treaties do not distinguish between investors on the basis of the ownership. This situation is evolving with investment treaties come to address SOEs more explicitly and frequently by making a reference to enterprises that are governmentally owned or controlled in the definition clause. Some investment treaties even go further to explicitly cover states as investors. By contrast, explicit exclusion of SOEs as qualified investors is rare in investment treaty practice. The rationale for explicit exclusion of SOEs in the definition of investors may vary in states. Obviously, it will clarify the status of SOEs as protected investors. And for some states, it would also ensure that SOEs are not used to circumvent international obligations. In investment arbitration, many tribunals and respondent states have not really addressed the status of SOEs, suggesting that sovereign investors are assumed to be covered by the broad definition of investment provided by most investment treaties. However, in view of the unique characteristics of SOEs, whether SOEs are protecting investors can be problematic. For example, in the Heilongjiang case, we've seen that the issues have been discussed by the tribunals. And in that case, the respondent state argued that the Chinese SOEs did not qualify as investor under the China-Mongolia bilateral investment treaty. The ancestral tribunal did not accept this argument and found no basis in the investment treaty to impose restrictions on investors based on their organization, business purpose, ownership, or control. So for the tribunal, the state ownership was not relevant for the purpose of the status of SOEs as economic entities under the applicable treaty. In addition, there's no evidence that the Chinese SOEs acted as quasi-instrumentality of Chinese government or under its express instruction. Similarly, in Tatneft versus Ukraine case, And Central Tribunal determined that the SOE in question was not controlled by the Russian government according to the structure and functional tests, while the tribunal found it's unnecessary to decide whether the public entity are eligible to make claims under the investment treaty. The Paris Court of Appeal, during a setting aside proceeding, ruled that the BIT's tax does not mandate that investors be private entities. Furthermore, the court held that the SOE's connections to the government did not deprive the company of its structural, organic, and decisional autonomy. So the SDS cases reveal that many investment tribunals accept SOEs as protected investors under investment treaties. But when the investment treaty does not clarify the status of SOEs as protected investors, tribunals will need to interpret the issue and their decisions remain uncertain, as it depends on the structural and functional tests applied to the specific case. So for example, in the case against Mexico, the majority of the tribunal held that being state-owned did not alter the commercial nature of the SOE's activities and the private nature of the relevant investment, and the BIT did not exclude SOE from its scope. However, one of the arbitrators held that the claim fell outside the scope of the tribunal's jurisdiction because the SOE acts as an agent of the state. The next question is whether SOEs has standing before investor-state arbitration. And this question is linked to, but different from the SOEs as protected investors under investment treaties. The standing of SOE is particularly complicated in the context of exit arbitration. As reflected in the Exit Convention, the jurisdiction of the exit tribunals is confined to disputes between a contracting state and a national of another contracting state. So in other words, exit has no jurisdiction to arbitrate disputes between two states or between two private entities. According to Article 25, paragraph 2b, a national of another contracting state is defined to include any judicial persons. So it appears that the state-owned enterprises can be considered as a national of another contracting state. But some argue that the preamble of the Exit Convention and the report of the executive directors emphasizes the promotion of private international investment and private international capitals. So exit arbitration is exclusively to private investors. And that means that SOEs, even if qualified as protected investors, are not eligible to access to exit arbitration. However, as of today, no exit tribunal denied jurisdictions to SOEs as claimants. The CSOB is a landmark case as it appears as the first case where the tribunal have adopted and applied the test outlined by Exit Chief Architect Aaron Brauchis. To be specific, according to the Brauchis test, a mixed economy company or governmental corporation should not be disqualified as a national of another contracting state unless it is acting as an agent for the government or is discharging and essentially governmental functions. In the CSOB case, the tribunal held that in determining whether SOE discharged or exercised governmental functions, the focus must be on the nature of these activities rather than their purpose. The tribunal concluded that the activities of CSOB were essentially commercial in nature, although the SOE was promoting the governmental policies or purpose of the state. And in Beijing Urban Construction Group versus Yemen case, the tribunal upheld the application of the Brauchis test in line with the CSOB, concluding that the Chinese SOE participation in an airport project was commercial. And in particular, the Chinese government's role as the ultimate decision maker was, in the words of the tribunal, that too remote from the facts of airport project to be relevant. Similarly, in the Master versus Span case, the tribunal adopted CSOB reasoning and rejected the argument that the dispute was between two states, finding that the SOE did not exercise a public function, nor the government exercise a control over the claimant and its investment decisions. Although the broad-case test is described as probably the best guidance for the deciding SOEs as the claimants under exit arbitration, actually the test does not resolve the problem, but leave considerable confusion in its application. And the tribunal's decision indicate that SOE standing under the exit convention is determined not by its structure, but by its function. And in assessing the function, the tribunal should focus on the nature rather than the purpose of the activities. However, distinguishing between the nature and purpose of the activity is not always clear-cut. And given the difficulty international tribunals face in discerning the true purpose of an activity conducted by foreign investor, a more reliable assessment might instead rely on the effect of the activity. And here the definition of investment could play a role. While it is uncertain whether future tribunals will accept and apply the broad-case test, it is evident that the number of disputes featuring SOEs as claimants has increased dramatically over the past decades, and the standing of SOEs is expected to face closer scrutiny in investment arbitration. So as we review the ICS landscape, it becomes apparent that we are experiencing the winds of change. Reform efforts are being discussed and debated before the Uncitral Working Group 3, and the ICSID, as a leading institution in the ISDS, conducted its most extensive modernization and released its new rules and regulations in 2022. And in parallel with the rise of SOEs as investors and claimants, the negotiation of some treaties offered a new avenue to adopt innovative SOE disciplines. And the typical examples include the CPTPP SOE chapter, which is arguably the most ambitious attempt to regulate SOEs at the international level. And we know China has formally submitted a request to rejoin CPTPP. Although the outcome is far from assured, China's application clearly indicates that China is prepared to embrace the CPTPP's SOE rules. And another example is the EU-China Comprehensive Agreement on Investment, where China has formally agreed for the first time to incorporate the SOE disciplines. Although this treaty is currently pending, its implications for SOE regulations and investment treaty making should not be underestimated. So what is the challenging and prospect? SOE acting as an investor and claimants have posed significant regulatory challenges for host states and required tribunals to interpret the application of investment treaty provisions and the ICSID convention. In practice, the central question focuses on whether SOEs are qualified investors and has standing in investor-state arbitration. However, a more profound problem caused by SOEs as investors is the blurred boundaries between public and private, attributable to the unique features of SOEs, including state ownership and the operation in non-commercial capacities. So in this context, a revisit of investment treaty regime seems necessary and desirable. For the host states, they need to consider whether they are prepared to face challenges from the foreign SOEs, foreign state-owned investors in international arbitration, or if they would prefer to exclude foreign SOEs from investment treaty protections to avoid potential SDS claim. And for the latter option, it is also important to be aware of the potential negative impacts this could have on investments by foreign SOEs. Although treaty-based investor-state arbitration appears promising for SOEs as claimants according to the existing jurisprudence, contract-based arbitration should not be overlooked. And compared to treaty-based arbitration, the standing of SOEs tends to be less contested in contract-based arbitration, although another issue may arise as to whether the dispute is purely contractual claims. I think I should stop here, and thank you again for your attention, and I look forward to the discussions. Thank you.
Thank you, Wang Liu, for that very effective overview of the current legal landscape. And so we can see what some of the fundamental questions are in terms of to what extent should SOEs be subject to different treatment, to special rules. And we see that there are certain issues arising generally under investment treaties, and then a few issues that are particular to the ICSID convention. We're going to transition a bit from the legal landscape to more of an on-the-ground look at the factual reality of SOE investors. And our next two presenters will be focusing on more of that on-the-ground factual reality. We can start with Hugh, who will be discussing some of his experience, particularly with construction and with SOE investors. And after Hugh, Vivian Lee, again, who is joining virtually. Vivian can share some of her experiences as well in the construction sector. So Hugh, please.
Thank you, Mark. I'll just pick up from what Wang Liu said in her speech, in her presentation. And I think she started off with the increasing important role of the SOEs or Chinese SOEs in the international market. And I think many of you would agree that the most high-profile and obvious example of the Chinese SOEs flexing their muscle in the international market is the Belt and Road Initiative. The Belt and Road Initiative, I think everyone knows, is a Chinese state-driven initiative, and so unsurprisingly, the companies or the Chinese investors leading that charge are Chinese SOEs. The investments into the BRI countries are over a number of countries. They are made in a number of countries. And these countries, I think many will agree that some of them are not well known for upholding the rule of law, which I think then brings into prominence the importance of treaty protection and invariably the possibility of treaty arbitrations if these Chinese investments going into the BRI countries should be compromised or by government action, some form of government action. And so on that note, I start on that note that with the increase of Chinese investment by Chinese SOEs into the BRI countries, it is foreseeable that increasingly there would be, we would see treaty arbitrations coming out of the investments into the BRI countries. The next issue I'd like to touch on would be whether it is possible that the Chinese SOEs would be deprived of protection because treaty protection, because they are Chinese SOEs. Personally, I think that would be unlikely. As Wang Liu has said, there aren't any cases where treaty protection is deprived because a company or a claimant seeking protection, treaty protection, is an SOE. I would be surprised that that would be different for investments into the BRI, especially applying the brochures test. I don't think the SOEs participating in the BRI are actually acting as agents of the Chinese state or discharging governmental functionality in their investments into the BRI. But I don't think it would be unforeseeable that a clever lawyer when faced with a claim, would actually come up with an argument that the BRI is a directive of the Chinese state, and Chinese SOEs participating in the BRI are actually acting either as agents of the Chinese state or discharging a governmental functionality. But again, I think that's where the brochures test becomes quite important. I mean, personally, if you apply it correctly, that shouldn't be a correct argument. But then, quite often, as we all know, encouragement with incentives by the Chinese government, trying to distinguish that from a directive, the lines can sometimes be blurred. Quite similar to conversations which I have with my wife. I don't know whether she's encouraging me to do something or directing me to do something. So, so moving on into my area or specialty, I'm not an expert in investment arbitration, I must confess first. So I deal a lot with construction disputes, and I deal a lot with construction companies. And funnily enough, most of the BRI projects are actually construction projects. They're not really investment projects. The majority of the investments involve construction projects, Chinese companies going to the BRI countries, building all sorts of infrastructure for the host countries. And all of these projects will be premised on contracts, and very detailed contracts that are signed. So the question will be, how many of these projects, how many of the disputes or claims will actually end up in treaty arbitrations? My suspicion is most of the disputes or claims would go the contract arbitration route rather than the treaty arbitration route. Okay, at least I think that will be the case. I won't be building a practice based on investment arbitration because I won't be able to pay the rent. So it's more likely that a lot of the disputes coming out of the BRI would be contract-based arbitration cases rather than investment treaty cases. But it is possible that we will see a few. I don't think there will be many coming out of the BRI, despite the scale of the BRI, and I would hazard a guess as to why this might be the case. I think, at least from what I've seen, in many of these projects, if there was any thinking that the treaty arbitration route should be employed, I think one reason would be the claims or the losses that the claimant or the Chinese SOE claimant wants to bring falls outside the scope of the underlying contracts. So quite often, contracts are signed where there might be an imbalance in the bargaining positions, and in the contract, some of the SOE claimants may have signed away certain rights where they are unable to claim certain losses. This happens quite a lot in construction contracts where you agree to limit your claims to certain types of losses, but not other types of losses. So that's one possibility that you may go down the treaty arbitration route in order to claim losses that are not possible under the underlying contracts. The other possibility where certain claims are actually debarred under the underlying contracts. So in construction contracts, quite often you have very strict claims provisions which imposes time bars if certain notices are not put in on time. And also you may have cases, and I have seen cases where claims lie dormant for a long time, and issues of limitation periods set in, and the claims underlying contracts are unable to be prosecuted under the contracts themselves. The third reason, which I think is possibly quite likely to be the real reason why treaty arbitrations have to be resorted to, is in the underlying contracts, the Chinese SOE has signed up to a dispute resolution clause that is not very friendly to them. For example, disputes are to be referred for resolution by the local courts. And when you are actually dealing with a government entity or the government, I don't think any Chinese SOE would particularly rate its chances of succeeding on its claim in the local courts. And therefore, you have to jump out of the framework of the contract and therefore resort to the protection of treaty arbitration rather than a contract-based arbitration. I think that concludes my observations and comments, and I thank the opportunity for being able to participate in this event and also to be set with such prominent members of the industry. Thank you.
Thank you so much, Hugh, for raising really interesting issues about the role of BRI. How might BRI affect the analysis? How might BRI complicate the analysis? I'm teaching an investment treaty course right now, and one issue that we discuss is thinking about the US, EU, and China with respect to investment treaty arbitration right now. The EU obviously wants to move to a court. The US at the moment, at best, is ambivalent at best. So of the three, I think China probably looks like the strongest supporter of investor-state arbitration, and BRI obviously is playing a role with that support. But then you raise the question, does the existence of BRI possibly complicate the analysis of the availability of treaty protections? So continuing our discussion of realities on the ground, we're going to turn to Vivian Lee, who I understand is joining us virtually. Vivian.
Thank you, Mark. Thank you, everyone. Thank you, Mr. Liu and Hugh, for the extremely insightful presentation. I also want to thank WAU and BAC for having me. Unfortunately, I cannot join you in person this time, but I'm grateful for the opportunity to connect virtually, and I hope you can hear me clearly. As Mr. Hugh mentioned, Chinese SOEs are big players in global construction market, and they have a strong presence overseas, particularly in the developing regions. So today, I will share my experience working with the Chinese SOEs doing construction project overseas, some of the challenges they face in arbitration proceedings, and I will also touch upon some good practices that I've observed, which may be implemented by the Chinese SOEs. Construction projects constantly generate one of the largest percentages of commercial disputes. In terms of investment arbitration, while the number of construction cases is lower, they still constitute a big portion. They made up around 10% of the total number of investment arbitration registered under exit. And by May 2023, Chinese SOEs have acted as claimant in about 22 investor-state arbitrations, of which about 1/3 arise out of construction and manufacturing. The reason so many construction projects ended up in international arbitration is because they are cross-border in nature. Due to the technical complexity, they rely on the expertise of contractors and subcontractors from around the world. The sheer size of these projects also requires funding from a range of domestic and international investors. These projects also require heavy upfront costs, and they run for a long period of time, during which they will be exposed to many risks, such as political instability, geopolitical tension these days, and supply chain disruptions, especially during the COVID period. How these risks are managed vary from one SOE to another. For the Tier 1 Chinese SOEs who have decades of overseas experience, there's usually a very diverse project management team on the ground, which plays a crucial role in collaborating with the local regulatory bodies, subcontractors, and suppliers. For that reason, these SOEs are extremely sophisticated in almost every phase of a construction project lifecycle, from project drafting, project management, and dispute resolution. In that sense, I do not see a huge difference from these Chinese SOEs and any other top international construction companies. I think the ones who tend to struggle a little bit are the mid-sized contractors who have limited exposures overseas. One important reason I would say is that there has not been enough emphasis on contract management. Well, it goes without saying that a good understanding of contract is crucial, but oftentimes we see parties do not fully understand the risk allocation. Even when the contractors do review the contract, they also tend to focus on those cost-related clauses, where time-related clauses take a backseat. As someone who often deals with project delays and disruptions, I really recommend the contractors and the legal advisors to pay more attention to, and also to comply with those contractual procedures related to, for example, the time required for serving notices, the duration required to update the programs and the progress records. These good practice can go a long way towards recovering general loss and damages, as well as prolongation costs. The second and probably the most important practice for all contractors, including SOEs, is to maintain project records. I cannot emphasize enough the importance of document control in international arbitration, because it has a very high threshold for parties to prove their case through documentary evidence. It is essential to keep a full and up-to-date records. These records should be stored in a centralized platform and should contain all relevant details to allow the issues to be understood by others, including others within the organization, as well as external advisors and consultants in the event they are brought in. Speaking of external advisors, I think a lot of the Chinese contractors are a bit hesitant to engage one unless it's absolutely necessary. And I think this might have to do with the traditional approach in the domestic litigation and arbitration, where parties try their best to use their in-house team to do as much as they could. However, I often see this approach not being to work very well in international arbitration, because tribunal and the legal team are sophisticated. If it is a biased and one-sided claim, the other side can easily cross-examine it, and the tribunal will not believe it. And therefore, you're not standing on solid ground anymore. However, as parties are also becoming sophisticated, it has been increasingly common these days to see Chinese contractors engage external legal counsels and experts even before the start of arbitration to allow them to do a sense check. I think most of the contractors find it helpful to have such an unbiased assessment of their potential entitlement and exposure at the early stage. This can assist them in determining whether or not we should go for arbitration. And even if they decide not to go, this piece of advice is still valuable in the process of settlement discussion. That's why, based on my experience, contractors benefit tremendously from carrying out a neutral risk assessment at the early stage, rather than adopting a wait-and-see approach towards the end. I'm conscious of the time, so I'll probably pause here. Back to you, Mark.
Thank you, Vivian, for really interesting points there on the role that the construction sector plays and how so much SOE investment is in the construction sector. And one thought that came to mind was, as we think about protecting classic FDI, physical projects, it's interesting to think about that so much of this SOE investment is what we think of as kind of classic FDI that absolutely should be protected by investment treaties. We're not getting into intellectual property. We're not getting into financial instruments. These are more of the classic old school kind of investment that's being made by SOEs. We're now going to turn back to the legal landscape, and Ian Laird is going to share views on the legal landscape, in particular treaty practice. Ian, please.
Thanks very much, Mark. Really happy to be here on this panel with you and with our other panelists. This is, as Jose Antonio talked about in his introduction, this is a critical topic and is certainly generating more discussion. Just sort of going back to some of the comments that Professor Wang made, and I want to touch on a couple of points. I think, as she mentioned, the idea that a state enterprise would be involved in ICSID arbitration, for instance, really goes back to the beginning of ICSID in 1965. ICSID was, in its original state, viewed as a mechanism for contract disputes. Bilateral investment treaties and free trade agreements were far and few and in between, and it really wasn't the thinking of the drafters that they would become this mechanism which would facilitate international arbitration for some 3,000 treaty mechanisms that exist today. So contracts were very much top of mind. And Aaron Brockes, who Professor Wang was mentioning, who was the first Secretary General and one of the key drafters of the ICSID Convention, taking that into context, he understood the key role of state-owned enterprises in investment. And, you know, and this is the 1960s, 60 years ago, you know, big construction projects were the meat and potatoes of ICSID arbitration in those old days. So the context hasn't really changed, and the concerns about how you would apply, you know, what we call now the Brockes test has been around for 60 years. So this is a long discussion. And part of the context of this discussion, of course, is relates to attribution issues in general. We have the International Law Commission drafted and spent many years working on the articles on state responsibility, which address some of these concepts as well. And, you know, talking about teaching your ISDS class, we have a similar class on attribution, and it really goes to the question of what is government. And the ILC articles set that out. You know, we usually think of government as, you know, the departments and, you know, the courts and the executive, but it clearly there are entities, sometimes state-owned entities, that carry out a governmental function. And I think that's the key phrase that both Brockes has used, as well as the ILC articles. And we see that the tribunals have, you know, talking about the tribunals that Professor Wang mentioned, they've really grappled with this issue of understanding the nature of the investor and, you know, similarly, the nature of the investment. And what really comes out in all these cases is that the investment is commercial. They're involved in commercial projects, and, you know, in some of the cases cited, you know, they could be airports, they could be roads, very, you know, construction projects for the most part. And those are commercial. Those are not deemed to be governmental. Whereas, you know, what is a governmental function has, I think, fairly lost kind of its specific meaning. And I think this is where some of the tension comes in the tribunals as to, you know, what that would entail. And we've seen a solution to this, rather than sort of relying on a test, you know, from the ILC articles or the Brockes test. We see the treaty drafters have very specifically addressed this issue. And, you know, I'm looking at the China-Canada Foreign Investment Protection Agreement from 2012. And in Article 2, Sub 2, the parties agreed as to what that governmental authority, governmental function would be. And they gave examples, such as the power to expropriate, grant license, approve commercial transactions or impose quotas, fees, charges, and so forth. And the key part of that clause is that this is delegated. So if you are looking at a situation where there is a delegation, and delegations are usually have kind of a legal character and are formal and involve those types of powers, then that's the kind of thing that those treaty parties, Canada and China identified as part of that governmental function. And I think the treaty drafters have actually done a service here in kind of removing some of that ambiguity. But again, looking at the history of this, and Professor Wang mentioned the CPTPP, the Trans-Pacific Partnership Agreement. That agreement has that kind of language in it as well, just defining the scope of what would make a state enterprise a governmental function. And if I was actually digging through kind of some of the history on this, and if you go back to the NAFTA, the North American Free Trade Agreement from 1993, the NAFTA parties actually devoted a chapter 15, to state enterprises, and they provided a similar definition. So, you know, just to be a little contrary to Professor Wang, and I know she was trying to be a little provocative in her role, and I think that's all part of the conference. I think there are mechanisms that exist in the treaty drafting that can provide some more certainty. And I'll finish on this point. Part of the nature of international law and treaties is there is some measure of uncertainty. And we saw Professor Zhang yesterday start her discussion mentioning the concept of constructive ambiguity in treaty drafting, which, you know, like in any contract or any kind of negotiation, there are certain terms and concepts that sometimes don't get the level of detail that would exist in a perfect world, or that a perfect set of lawyers or you know, negotiating parties would like. And part of that is what drives some of these cases, is the definition of investor, and the scope of what an investor could be can be not ambiguous, but not fully defined. And I think this is one of those issues that treaty drafting, like the CPTPP and like the China-Canada FIFA, can address much of that issue. So just on a related point, I think there are other tensions as well in ISDS, and Professor Wang talked about the reforms that are going on at ICSID and at UNCITRAL. And there is no doubt that by submitting these types of treaty clauses to a form of dispute resolution, that creates a potential for uncertainty, because every treaty has some differences. The parties are different. The state-owned enterprises are not uniform by any measure. So that requires looking at the specific facts of each case and examining them in a judicial function. And that's sometimes, you know, not as easy as it sounds. That's why we have judges. But that in itself creates a little bit of uncertainty. The rule of law isn't always a certain process. But I think for the most part, and I guess this is my final point, and I'm actually quoting Professor Wang here, she said there are no ICSID cases have denied jurisdiction to SOEs who have acted as investor claimants. And I think that is a reflection that tribunals have been cautious. They haven't gone out, they haven't expanded the terms they've seen in the treaties. They've viewed a very conservative approach in maintaining a view that unless you can demonstrate, again, on the facts and in the circumstances of that case, that there is a specific delegation of some function, governmental function, then they're not going to step outside their bounds and say somehow that this state-owned enterprise is acting as a government. And I think that that's a really important point. There is, I believe, a measure as much as possible of consistency in the jurisprudence that should give some confidence. Not perfect confidence, because you could never guarantee that, and certainly no lawyer would ever do that. But the law has been relatively consistent on that point. So I'll stop there, but a very interesting presentation, Dr. Wang, and really appreciated that.
Thanks so much, Ian, for that terrific deeper look at the legal landscape. And as you mentioned, that when there are situations where we need to determine when an actor is acting as a government, we have very well-established rules, right? We have well-established attribution rules, the ILC articles you mentioned, the Brockus factors, in my view, and I think the view of many others, the Brockus factors basically track two of those ILC articles. So we have very well-established rules for determining when an actor is acting as a government. And I think in terms of treaty practice, if parties to a treaty want to depart from those customary rules, they're free to do so, and they're free to take a different policy in their treaty, a lex specialis, and depart from the underlying customary international law principles. So thank you again, Ian, for that discussion. We're now going to turn in particular to the topic of Chinese SOEs. Cao Lijun is going to be leading that discussion. Cao Lijun, please.
Thank you, Mark. Good morning, everyone. It's a pleasure to be here participating in this important event. Well, I think I agree with all that has been said by my colleague, Professor Wang, Ian, and Mark himself on the legal issues in relation to, SOEs as covered investor and the international investment documents, as well as its standing, particularly in the context of exit arbitration, exit convention, as well as the broadcast test and the issue of attribution. For the Chinese practitioner, when we talk about this issue of SOEs standing, we always only focus on really two cases. One is Heilongjiang versus Mongolia, and the other is Beijing Urban Construction Company versus Yemen. Those cases, Professor Wang already mentioned, but participating discussion in this session, I have truly learned a lot from three of them. The other cases and particularly the attribution issue. I also concur with Hugh and I think it's Vivian from Secretariat in their observations, particularly Hugh's observation that sometimes investor, because the contract clause is not necessarily friendly to the investor, Chinese SOEs, so they may need to look beyond the contract and seek other remedies, seek other rules for remedies. I think for today's purpose, I just give two of my observations because in recent years, we have been frequently inquired by Chinese companies, many of whom are SOEs, in relation to their or outbound investment, particularly in the BRI countries. From those contexts, I noted that there are two tendencies. One is the Chinese companies, Chinese investors, particularly SOEs, they still tend to be reluctant when it comes to consideration of filing a treaty arbitration. If we talk about this topic 15 years ago, most of the SOEs, their in-house counsel, they are not aware of the option for filing ISDS. But because of events like this, they have received legal education over the 15 years time. So nowadays, if you have any conversation with the in-house counsel of the SOEs, which are engaged in outbound investment, most of them, they are aware of this option. They know beyond contract remedies, they may still have a treaty remedies under the bilateral investment treaty or a free trade agreement between China and wherever they are investing. However, the reluctance still exists. I think one of the main reasons has to do with the Chinese culture. The Chinese persons, legal person, judicial person, they tend to try to avoid any dispute with the government. So there's no tradition of taking on government agency in any form of legal action, and that also happens when it comes to legal actions against a sovereign state outside China, right? The other reason I think is because of they are more or less sensitive to the diplomatic relationship between China and the particular host state that where they are investing. But I think this is a overrated concern. It's not a necessary consideration because not every investment outside China, not every dispute may have impact on the bilateral relationship. It may have an impact only if it's really, huge investment and huge losses are at stake. However, in practice, some of the SOEs, when they come to us for inquiries, they always ask a question like this: do you have any channel of, conversation or communication with the Ministry of Foreign Affairs or Ministry of Commerce? Because when they invested outside China, they probably was encouraged by the government, maybe central government, maybe local government to invest. Maybe SASAC, maybe NDRC. They know when there is dispute, those organizations, those government agencies may not be the right government agency to communicate with. But any communication with Ministry of Commerce or Ministry of Foreign Affairs, that's not required in any Chinese law or any Chinese regulation. But they still want to seek not approval, but some sort of endorsement before taking any legal action. That's one observation. The other observation is about the accountability issue. The management team of those Chinese SOEs, a lot of time they have to seek legal remedies because they are required to do so. There are quite a number of regulations, but one important regulation is this, what is called 中央企业法律纠纷案件管理办法, the measures on managing the legal dispute cases of central SOEs. This one was issued by SASAC in 2023. If you look at the provision, it basically says for cases involving 50 million RMB or equivalent in foreign currency, it's not a very high value. The SOE involved needs to report to SASAC, and the report shall cover details of the case, the legal analysis of the dispute, a prediction of the likely outcome, as well as the plan for next steps. It also says after completion of the case, the legal document needs to be reported to SASAC within 10 days. The central SOEs shall set up a mechanism for monitoring important cases. It also says any person who commits wrongdoing in relation to management of the business or management of the cases will be held accountable and will be subject to penalties. So it's also made clear at the preamble or the first few articles that the purpose of these provisions is to prevent losses to state assets. Here, maybe Professor Wang can tell that it's also a blurry there between, the sovereign assets and, the assets authorized by the state, but independently operated by the SOEs. I think this provision is not designed solely for ISDS, but it certainly covers ISDS. Remember, when I mentioned 50 million, it also says equivalent in foreign currency. So apparently it covers the outbound investment dispute arising from outbound investment. So because of those regulations, SOEs, when faced with a potential dispute against a host state, the management, they will be under pressure to pursue legal remedies, including pursuing legal remedies through, treaty arbitration. So, and there is also a inspection from the above organization, also including inspection within the party itself. So that's why, the management a lot of time they have to go through this treaty arbitration mechanism. But even in the legal proceeding, there are a few tendencies. One of which is that the management tends to, avoid settlement. Settlement also leads to the accountability issue. So they cannot easily compromise in most of the situations. Although I see there is a possibility of settlement in some cases. For example, if the host state, previously revoke a mining license, but through the arbitration, they are willing to restore the investor, give them a new license, then probably there's no reason for the management to say no, and the management do not think they will be held accountable for whatever decision they have made, then there's a possibility for settlement. But most of the situations, if any compromise is to be discussed, I think the management will say no. They will just say, let the arbitral tribunal make the decision. We will just report the outcome to SESEC. And the other possible tendency is, I didn't know this from practice, but I think that's also going to be true, is the management, they also want to avoid third-party funding. Because if there is third-party funding, that means a percentage of the outcome, whatever they receive from the award, if they won the case, is to be allocated to the third-party funder. Those may be categorized as state assets. No management team member can afford, being, criticized in the future by, making use of improper funding, and at the same time losing state assets. That's basically my observation. Thank you.
Thank you, Zhao Lijuan, for really interesting points from the inside in terms of Chinese SOEs. And you had mentioned the increasing awareness of in-house counsel, of protections under investment treaties. And with respect to outside counsel firms in China, I think what's happening right now in China with investment arbitration, it reminds me of what was happening in the US and Europe in the 2000s. I was with Ian Laird in DC in the 2000s, and at that time you had a lot of big firms with big commercial arbitration practices slowly migrating over into investment treaty work. And I think that in China, that's exactly what's happening right now. You have large firms with large commercial arbitration practices getting up to speed on investment arbitration. They have the clients, they're getting ready to go to have a larger and larger role. And obviously, Zhonglun has played a key role in that process. Okay, we're now going to turn to Dr. Wang Shuihua, who I understand is going to be joining virtually. Is that, yes? Dr. Wang.
Yes. Thank you, Mr. Moderator. Can you hear me? Yeah.
Yes.
Okay. So the standing of SOEs in the investment treaty arbitration is a very important issue. So I truly appreciate today's seminar on this topic. With the in-depth implementation of the BRI, Chinese state-owned enterprises have been consistently active and playing a very important role in the BRI investments. The status of SOEs has long been a complicated issue in international investment arbitration. So just now, Professor Wang Liu has made a very thorough, complete, and instructive lecture on this main topic. So I would just like to ask several points there. And first point is regarding the qualified investor definition. I think we can conclude from Article 25 of ICSID Convention that ICSID is a forum of investor-state dispute settlement, ISDS. And second, a national of another contracting state may include a judicial person, which in principle include a SOE. Okay, so that's what we can draw from Article 25 of ICSID Convention. The overwhelming majority of investment treaties rarely make any distinction between SOEs and privately owned enterprises. So that gives rise to some doubts or some ambiguity of the definition of the SOEs in the investment treaty arbitration. So you gentlemen have also talked about the Brock's test. I think Brock's test is very important in understanding the history and the true meaning of the Article 25 of ICSID Convention. And what's worthwhile mentioning is the Brock's test turns out to mirror the customary international law rules of attribution, which can be embodied in Article 5, 8 of draft articles on responsibility of states for internationally wrongful acts. That's one point I would like to make. And concerning the ISDS practice in this field, I fully agree with Professor Wang Liu that no ICSID tribunal has denied any jurisdiction over the SOEs, especially concerning the two Chinese cases. And one thing it's worthwhile mentioning is the BUCG versus the Yemen case. The tribunal found that Chinese states' involvement in key decision-making at BUCG was irrelevant to the purpose of determining whether BUCG was discharging governmental functions in specific instances. This is a very important principle, right? Because it reviewed the common corporate framework for Chinese SOEs. And this case may be seen as setting an important precedent in the treatment of Chinese SOEs in international investment arbitration. This case, I think, is worthwhile. Chinese states' involvement in key decision-making at SOEs is irrelevant. It's irrelevant to the purpose of making any determination whether they are qualified investor or not. The important thing is you have to look at the characteristics of the investment itself. So I think this case is worthwhile mentioning here. And third point I would like to make is I could make a very simple summary of the host state's position and tribunal's method of analysis in determining the qualification or standing of SOEs in investment treaty arbitration. The host state's jurisdictional objection are often seen to be raised on grounds relating to inherent characteristics of SOEs, such as the operation and management of SOE is controlled by the state. The behavior of the SOEs is in close relevance with the implementation of the national policy. Host states would, to some extent, be the ultimate beneficiary of SOEs investment, etc. So that's the host state's position. And the tribunal's method of analysis, if I could make summary, is that tribunal preferred to focus on the nature of the specific investment instead of SOE's inherent characteristics. So as long as the claimant prima facie satisfies the minimum requirements of a national, the arbitral tribunal tends to consider SOE to be a qualified investor. And the burden of proof is imposed on the state party. Once the respondent fails to establish that investors are agents of the government or investment is actually fulfilling government functions, it would bear the unfavorable, otherwise it would bear the unfavorable consequences. So that's the summary I would like to make. And last, I would like to think an advice to the Chinese SOEs. So given that only the commercial and private activities of SOEs are subject to the protection of the convention, it's a convention, so I think Chinese SOE is well advised to operate independently and act in conformity with the laws of home country, as well as the customary international law and local laws in the host countries. So that's all I would like to make some points. So thank you for having me here. Thank you very much.
Thank you very much, Dr. Wang Shuihua. Really interesting legal points there. The BUCG case, obviously, is a key case in this area. And also, you raised the issue of burden. And it is interesting to think about burden, that right, normally the claimant would have the burden of establishing that it's an investor or a national of a contracting state. But with respect to a jurisdictional objection, the respondent raising the jurisdictional objection normally would have the burden to establish whatever objection it is they're raising, including the fact that perhaps because of a relationship with the government, that a party should not qualify as an investor. We have a few minutes remaining. We've heard a lot. We've covered a lot, both on the legal side and in terms of on-the-ground facts. I can open things up for our panel. Any reactions, any comments on anything that we've heard so far?
Well, I was very interested to hear the comments of Cao Lijun about kind of the concerns of state enterprises in terms of engaging in the ISDS regime. And I think that's the kind of concern that, frankly, not just SOEs have, but certainly all claimants who engage with that system. There's always that diplomatic element because the investor is foreign. There tends to be, interaction at the diplomatic level in some of these big disputes. So that's very similar. The idea of seeking to avoid suing a state, that's definitely the motivation of my commercial clients as well. They really don't want to do that. That's something that grinds against their better judgment for the most part. And coming to that conclusion really is predicated, just as was said earlier, on situations in which, frankly, the company just has no choice, where there's a bet the company is what we call a bet the company situation, in which the losses are just so significant to the bottom line that just frankly from a responsibility point of view of management, it just can't be ignored at that point. And I think that's a very typical kind of situation for all investors faced with similar challenges. So I don't think it's just unique to SOEs, although I do understand there's certain regulatory and other responsibilities which make it even more important that they get the decision right. But in those significant loss situations, it's definitely an option, especially when government measures are at issue in the foreign jurisdiction, going beyond a contract dispute. Then that's something that's always worthwhile to look at as a potential remedy.
Thank you, Ian. Other reactions from the panel?
Thanks, Mark. I think we've spoken a lot about whether SOE should have their investments protected, whether they are a protected investor. I think more or less concluded that they should be. But I think if we go back to what you started with, should the relationship with the home state matter? And I think it still does matter, even if you're a protected investor. And how should it matter? I think we haven't actually dealt with those questions because you might be an SOE and you do enjoy protection, but what is the protection that you enjoy? Are there differences in treatment that in the protection that a private investor should enjoy in that country between should a private investor enjoy different treatment or the same treatment? And that may come into play when we look at national treatment, most favored nation treatment. And there are some cases on that. I think UPS in Canada is a case on that. The other issue might be a bit more touchy, which is there are, I think, in many, probably all of the investment treaties, there will be exceptions, and national security is one of them. And when you talk about whether the exception applies, the national security exception applies, I think it is fairly obvious to see that there might be a difference in treatment where you are a Chinese private investor or a SOE. And so I think those would be issues which unfortunately we didn't have time to cover today. Thank you.
Thank you, Hugh, for raising those points. Other further comments?
Yan's comments just now is also helpful to myself understanding, because most of our potential clients or clients, they are SOEs. So I think those are the typical SOE mindset of their management team. Yan mentioned for other, even if private companies, they may have a similar mindset when it comes to bring up arbitration or lawsuit against a sovereign state. But in my practice, maybe your clients are basically large clients, which has maybe listed companies, so they have a similar issue. I do come across smaller Chinese private companies who are investing in Central Asia. They do have a much less concern in this regard. They may want to, have a sort of dialogue, not with the ministry level, but with the embassy. But in terms of accountability, their team is not a listed company, for sure. If it's a listed company, they may have the common issues. But they seem to have much less concern, and they want to make use of third-party funding. So it's a totally different scenario. Thank you.
Thank you, Li Juan. Wang Liu?
Thank you very much for all the comments from the panelists, and I learned a lot from today's discussions. And one thing I found is very interesting, and I will have enough time to cover actually in our session today is, the states have taken, increased number of states have taken measures to regulate SOEs at both national and international levels. As we've seen the increased national security reviews, and also, our panelists have mentioned about national security exceptions that might be an issue in the future. That's the arbitration involving SOEs. And another issue that I found is quite interesting and inspiring is, discussed a lot about the standing of SOEs in investment arbitration, and that as a primary and fundamental issues, but that is not the end of the issue. There's also the application of the substantive obligations under the investment treaties. And there's the issue of the interpretation by the arbitral tribunals when there's ambiguity in investment treaty provisions. And it's one of the things that is important is to see what it actually opens a prospect for the future investment treaty reforms associated with the SDS system reforms, that what states can do to address the concerns and to achieve the balance. And I think that is very thought-provoking for myself. And thank you.
Thank you, Wang Liu. We have about 1 minute left. Dr. Wang Huihua, Vivian Li, any final thoughts with the minute we have remaining?
Yeah, thank you. Can I make a final remark?
Yes, please.
Yeah, I would like to circle back to this equilibrium phenomenon Mr. Cao mentioned just now in the investment arbitration. I think despite a strong presence of Chinese contractors in global construction industry, so far they still have been very few cases where Chinese SOEs act as a claimant. I think that has something to do with this bifurcated approach China has taken towards international arbitration and investment arbitration in principle. I think on the one hand, China has embraced the international adjudication to settle investment disputes. However, on the other hand, it's still somewhat hostile towards the core issues, such as issues of sovereignty and territory issues. When these issues are at stake, I think the question of how much Chinese SOEs and Chinese government were inclined to resolve through arbitration is still a question mark. I think that sort of attitude is somewhat mirrored in Chinese SOEs' thinking process and also the attitude towards investment arbitration, resulting in some degree of resistance when they're contemplating about initiating any formal dispute resolution process against the host states. So I think it's an interesting question to think whether we should maintain this bifurcated approach, or at one point, there should be a more uniform approach, and whether that will help Chinese SOEs in participating in more investor state arbitrations. Yeah, that's all.
Thank you, Vivian Li. Dr. Wang Shuihua, any final thought?
No, thank you. Thank you. Time's up.
Okay, well, thank you, everyone. This has been a terrific discussion. Thank you again to Jose Antonio, to World Arbitration Update, to Beijing Arbitration Commission, to Ian Laird. It's been a terrific session. I really am glad I made the trip to Beijing. Thank you, everyone.